respective learned defense counsel then applied that each be released on bail bond on reasonable terms. Ms. Osoro, learned prosecution counsel, urged this court to first call for pre-bail reports before setting the bail bond terms, arguing that A, some of the accused persons' places of abode are unknown and they were traced using their mobile phones. B, that the accused persons are charged with offenses under the Anti-Corruption and Economic Crimes Act, which are very serious. And C, that the amounts of public funds involved in the case are substantial. Learned counsel for the respective accused persons did point out that the prosecution has not adduced any evidence to support the averment that any of the accused persons' places of abode are unknown or that any one of them is a flight risk. It was pointed out that some of the accused persons were summoned to report to the EACC offices at Kisumu yesterday, and they honored the summons, while others were aware that the EACC officers were on their way to arrest them at their places of work and yet did not flee. It was also pointed out that at this stage of the case, each of the accused persons is innocent until such a time as the court will pronounce their guilt. It is now settled law that after an accused person has been charged in court with a criminal offense, he or she is entitled to be released on bail or bond terms, on reasonable terms, and that the only time that this right can be taken away is where the prosecution is able to demonstrate to the court that there are compelling reasons that warrant the right to be taken away. This right is provided for in Article 49, Sub-Article 1G of the Constitution. Until the prosecution has raised grounds that would seem to indicate the existence of compelling reasons, the court must therefore assume that a person brought before it with a criminal charge qualifies to be released on reasonable bail bond terms